Welcome back. The Supreme Court handing down more bombshell decisions, striking down affirmative action when it comes to college admissions. Came down 6-3 in the University of North Carolina case and 6-2 in the Harvard case. Let's talk about it with Rachel Chiu. She's a Young Voices contributor, back up late with us here on the Final Five. We talked about this some time ago, before the decision came down. You're here tonight with us, so I just want to get your first take on what you saw happen today and whether or not you were surprised.
Yeah, so I think that this is a great day, a big win for equality and opportunity. About 45 years ago, the Supreme Court said that racial quotas were unconstitutional, but that race could continue to be used as one of many factors. As we've seen, race was used as more than just one small factor in the admissions process. So this decision is a big win for all.
We obviously had some very colorful opinions come down, both on the opinion and the dissent, including from Justice John Roberts, who said that I'm just going to read very quickly from the quote here, that basically these programs unavoidably employ race in a negative manner, involve racial stereotyping, and lack meaningful endpoints. That coming from the Chief Justice. Meanwhile, you had Justice Ketanji Brown Jackson, who had said it would be deeply unfortunate if the Equal Protection Clause actually demanded this perverse, a historical and counterproductive outcome. So just as we see the divide here on the country, it really is very starkly divided on the court as well when it comes to such a sensitive issue.
I think one of the most important points there is what Chief Justice John Roberts said about Endpoint. So in 2003, in a separate case, the Supreme Court affirmed the use of affirmative action, but did say that it can't last forever, that there has to be some endpoint, some termination. And we saw that that wasn't the case. If it wasn't for today and this ruling, affirmative action would have probably continued indefinitely, which is not what it was intended to do.
You know, as we look at this and as schools move forward and try to find ways to move forward, obviously this is going to change the entire dynamic when it comes to the admissions process, especially at schools like Harvard. Where do you see some of these schools changing their focus? What do you see them doing and how they approach this idea of maybe preserving certain ideas that they would like to see a certain number of various groups in their incoming classes? As
you said, race-conscious admissions has been a feature of colleges for such a long period of time. And so it remains to be seen how this ruling impacts the way that they go about the admissions process. But Harvard and several other universities have come out and said that they will try to find some way to preserve their interests and values. And so, again, it remains to be seen what that will look like. But ultimately, if any school tries to circumvent this ruling and continue to use race as they have been, I'm fairly confident that that will spur potential litigation and ultimately be deemed unlawful. Schools can look at a host of different broad-based diversity factors. There's more than just race.
You know, I'm certainly not bringing you on to defend or oppose anything here tonight, but there are a lot of people who have looked at this and pointed out that you have Justice Thomas, who, of course, is one of the concurring opinions here, who many argue was the beneficiary of affirmative action programs when he enrolled in law school decades ago. Then you have Justice Ketanji Brown Jackson, who was on the other side of the opinion, and those two did something that's very rare in the Supreme Court, where they appeared to take direct shots at each other there in their interpretation of this. Social media is what it is. Many people have said that this is for lack of a better term, the end of the republic, not necessarily quoting anybody directly there. You know, is this a new frontier that we find ourselves in when it comes to approaching these issues going into the 21st century and continuing forward?
I think that we can all appreciate how this is a very divisive issue and that people on both sides have very well-intentioned arguments here. But ultimately, I think what Justice Thomas said in his concurring opinion really speaks to what this was all about. And he said that the Equal Protection Clause of the 14th Amendment protects people of all races, that all citizens have equal protection under the law. And that's what this case was about.
There was something also that came in I'm reading through here, flipping through as I talk to you here. Justice Roberts says nothing in this opinion should be construed as prohibiting universities from considering an applicant's discussion of how race affected his or her life. That does seem to be paints a difference between what your race is and how it has affected or enhanced your place in this world.
Mm-hmm. And that's something that I hope we see moving forward, of looking at diversity as the lived experience of the applicant, to see if they want to look at race, how race has impacted their life, how it has inspired them. That means so much more than just checking off a box and saying, hey, you're of this race, and that will determine some feature of your application. So ultimately, I hope that we're moving towards a place in the college admissions process where we're looking at diversity as a broad concept, not simply as the color of someone's skin.
You know, when we look at the college admissions process, obviously this has been something that has weighed heavily in the process for a very, very long time. There were some other people, including Congresswoman Alexandria Ocasio-Cortez, who wondered, perhaps hypothetically here, what should be done when it comes to legacy admissions? What should happen if an alumnus or a donor believes that somebody in their family, somebody they know, should be pushed to the head of the line? It appears, though, that in that case, we're not looking at a benchmark like race that had been used in the past. So while it may not seem fair to everybody, it's certainly, there's no legal interpretation when it comes to things like legacy admissions, at least not now.
Mm-hmm. That's right. And there are so many ways in which the college admissions process can be improved. And so the inclusion of race was a very pernicious factor. But there's many other ways, again, in which this process can be better. We may want to think as a society if we still want legacy as part of the admissions process, but ultimately having these conversations is a good thing, to know that the process has flaws and hopefully we can work towards something better.
I think the best part about having this conversation that we're having, Rachel, is that you did present some ideas out there to consider, because I think you can paint it, when I use that analogy of people looking at the end of the Republic, we've endured a lot through our time in this country, and when you have these discussions, hard discussions to have, but at least ways to look forward, I think we stand together when it comes to that, regardless of where you stand on the issue. Rachel Chiu from Young Voices, good to see you again. Thanks for joining us tonight.
Thanks so much.
And the Final Five is back after this.